Yes, good. Hi, good evening, ladies and gentlemen. To all our colleagues, thank you so much for joining
Thank you so
us.
much for joining us.
And I want to say welcome once more to wonderful session here, the webinars that are presented here by the Clinix Health Group every Thursday from 6 to 8 o'clock. I just want to say thank you very much for two of our presenters here this evening. I'll introduce them in more detail shortly. Amber Lawler as well as Jenny Govender, and they are presenting all the way from Durban, and we are keeping them away from their supper and their dinner this evening. So we want to say thank you so much to them. They are from the Norton Rose and Fulbright firm. And again, I will give a bit more information about them a little later on. But just as a vote of thanks, I know that many of you have been attending these sessions diligently and studiously for some number of years now, and we want to express our gratitude to you. And it's your participation that enables us to uh, put together these presentations. And we want to remind you that we would gladly have any of you present. So please feel free to put up your names. We have many of you that ask questions, and you have lots to share and lots to learn. And I'm sure that we would like to get some of you to put up your hands as well and participate, and feel free to present if there's something that you wish to share with your colleagues that are on this platform every week. So in addition, I just want to say thank you, and I hope that you all clicked on the link and you registered yourselves so that you are able to receive your CPD points and any other points either from the HPCSA or any of the other bodies that you're affiliated with. If somebody sent you the link, you will be able to click and access the webinar, but you most likely will not be able to get access to your points. So please make sure that you are the one that registers directly for that. Normally, for anybody that's here for the very first time, uh, the manner that we normally present this is that we will make sure that while the presenters are on, this is Amber and Jenny. What happens is we generally mute your audio. We have people in the background like Sam and Nero who are controlling. So please put your hand up, and then we will be able to unmute you and you can ask your question directly. But if not, you have a chat session, and in that chat section, you're able to ask your questions directly. And we will read that out to Jenny and Amber, and they are brilliant. You can ask them all the most difficult questions that comes to mind. And if not, if we don't get through all your questions this evening, we will collate them, gather them, and then we will respond and share those questions with you with the answers subsequent to this presentation. So thank you once more, Jenny and Amber. I don't want to speak all evening. So as a means of introduction, Jenny as well as Amber, they are Durban-based, and they dispute resolution and litigation attorneys. And they focus on medical law and professional indemnity matters. They represent private hospital groups, public liability insurers, as well as a provincial department of health. And also, they also present healthcare practitioners, including nurses and doctors, in complex malpractice and indemnity claims. So they are members of Norton Rose Fulbright South Africa. Does this sound like you, Jenny? I see that you're getting uncomfortable here, but these are your achievements. So we wish to put you forward in this platform for your hard work. And they
Thank
are
you so much, Button.
correct, yeah. So Norton Rose Fulbright South Africa, they are actually a medical law firm that's got one of the largest specialist medical defense teams in South Africa, and advising on the defense of malpractice claims as well as regulatory and insurance issues in the healthcare sector. So we wish to welcome you once more, Jenny. We know that you hold a master's in medical law and that you are both admitted attorneys in the High Court of South Africa. So welcome again this evening, and we will be right here with you. And we look forward to your insights and sharing your special expertise with us this evening. Thank you, Jenny.
Thank you so much, Burton. I don't suppose I could have asked for a better introduction. I think you knocked it out of the park with that one. But I think I speak for both Amber and I when I say we're truly happy to be here. We're grateful to have the opportunity, and we'd like to see some good engagement. So yeah, let's just kick off. So, in terms of our presentation today, what we'll be looking at is medical malpractice claims, and we will be focusing on an overview of the civil litigation. And then we will be discussing South Africa's current litigation landscape, as well as looking at some practical case studies, which I am pretty sure you're going to find very interesting, and I have no doubt there will be some questions coming out of it. And then we will end off the session with a discussion on some case law that both Amber and I will be looking at. So, I'm going to start off the session with the overview of civil litigation. And I think before we even look at civil litigation, it's always interesting to understand the concept of the legal consequences that arise when you find yourself either as a doctor or a nurse in a position where your conduct is being questioned in terms of whether there's an allegation of negligence or there's an allegation of unprofessional conduct on your behalf. And what is interesting about this is it's not just a once-off consequence. It's not a consequence that just says, okay, there's going to be a claim against me. There's a multiple layered consequence that might occur. And one of it is you might find that patient decides to go the litigation route and they decide to bring a claim against you. Alternatively, they may decide that perhaps we want to take the regulatory route and go with an HPCSA complaint, which is the Health Professions Council of South Africa. And this is a regulatory body that regulates the conduct of your doctors and your allied healthcare professionals. For the nurses, you have SANC, which is the South African Nursing Council. So these two regulatory bodies receive complaints from patients, and you have a different regulatory process that occurs from these complaints. Alternatively, in cases where you have a patient who has passed away and the death is unnatural or considered to be unnatural, an inquest may also, the process of an inquest may start as well. So you may alternatively have criminal proceedings. And I think some of you may be aware that recently in the media, there's been much talk about litigation of criminal proceedings against doctors. And I think the most famous one is that of Dr. Beale, who was eventually found to be not guilty. But unfortunate for him, it was since 2012 to now to 2025, a fight that he had to have. You may also find some of the consequences is a disciplinary action that you'll have to deal with your employer. Alternatively, sometimes you may be considered to be a factual witness and called upon to give factual evidence relating to a claim, relating to an inquest, relating to sometimes a regulatory proceeding in terms of the HPCSA or SANC. And then for healthcare establishments, they also face complaints that may arise against them with the Office of Health Standards Compliance. Whilst these are numerous amount of legal consequences that I've highlighted, we'll be looking at medical malpractice claims specifically. But I thought it would be a really good idea for you to just have an idea in terms of what are the possible pathways that patients who intend to either litigate against a healthcare practitioner or a nurse may have. And what is interesting about this is that some of these can actually run simultaneously. So you may have a situation where you find that a doctor may have a complaint laid against him or her with the HPCSA, as well as a claim instituted on the same cause of action. Alternatively, if you have a death of the patient, you may see that you have an inquest, you have a regulatory complaint you have to deal with, and a civil claim. Each of them have some sort of consequence upon the other. And in most cases, what we are seeing is that often patients are now using the process of HPCSA complaints to see whether or not they in fact actually have a claim. And if they're successful in those proceedings, including SANC proceedings, then they decide to go the claim route. So when we look at medical malpractice claims, the basis upon which the patient may bring a claim is either based on contract or it is based on the delictual principles in law. And to unpack that a little bit, sometimes we see, and I think this is more often than not, a patient in their summons will be alleging both bases. One being the contract, and that's often referred to as your admission forms. Alternatively, they use consent forms. But the idea behind this contractual basis is that a patient comes to you to receive reasonable care, and the impression is you agree to provide the treatment. And when proper treatment is not provided, then there is a breach of contract in those terms. The terms of the contract will be relied on in terms of signing the admission form. So that it'll be partly written, and often you'll see it will be a verbal as well. There's a implication that when a patient comes to you for treatment and when you treat a patient, there's an implied terms of agreement that is the contract. That's where the contract arises. In terms of delict, and I'll go a little bit more into detail on delict, this is where we really look at the meat of these medical negligence claims, is looking at whether there is in fact negligence and causation, and effectively the harm that's caused out of that, and what is the damages that the patient has suffered. So when we look at the two main issues in any claim that we may receive, we will be looking at the main issue of liability, which is the first part, and then secondly, quantum. So often in cases of highly complex cases or where you have high quantum claims, particularly something that we see with cerebral palsy matters, you will often see that the liability portion is almost run as a trial on its own. So all of the issues of liability is dealt with first. And once that is considered, whether or not the healthcare practitioner and or employee of the hospital, and in the public sector, sometimes the MEC for Health as a defendant, if they're found guilty of being negligent, and we've understood that liability is going to the liability is resolved in terms of either an apportionment of 100% or a percentage, then we will proceed to the issue of quantum. So quantum generally starts to be dealt with and investigated once liability is settled, because you're then looking at how much you're going to be paying in terms of the damages or harm that's caused to the patient. When we look at liability, really what the patient who brings a claim has to prove is 5 elements of delict. In general, you're looking at the first issue of wrongfulness. And this really looks at it from a perspective of, was this conduct wrongful? And it's often in law, we look at the legal convictions of the community when looking at wrongfulness. So if the initial answer to that is yes, even on the face of it, generally you'll start to proceed to look at the other aspects of liability. The next question that you have to fulfill is fault. And in medical negligence claims, negligence is what you have to prove. The test for negligence is something that I'll speak about in the next slide, but the test for negligence is really something that has come out of the case of Kruger versus Coetzee, where they formulated the reasonable test. And once you are able to pass that Lego element, you also will then look at the conduct in itself. The conduct can either be an act or an omission. So it can either be, for example, where a doctor might have or a surgeon might have performed an incorrect surgery. That would be a positive act. An omission may be failing to properly monitor a patient during pregnancy, during the labor process. So those are some of the examples that practical examples and things that comes up a lot in a lot of these medical negligence claims, but just for you to understand the aspect of conduct. The most important, and I think perhaps anyone who deals with these medical negligence claims would agree that causation is a very, very important aspect of proving. And you will see that sometimes in cases we have negligence being proved, but causatively, if there's no real link between the negligent conduct and the harm that's caused, you may often find that a plaintiff falls flat on their argument, and they end up not being successful in their claim. And interestingly, there are some practical examples that Amber and I will discuss in terms of causation, just later and further down in this presentation. And then the last part is harm. And you have to prove that some harm or loss was caused. So it doesn't only mean that the conduct is wrongful and the healthcare practitioner or nurse was negligent. You also have to show that some harm or loss was caused. And the reason for this is the basis of your civil claims really is there's some compensation that the patient is looking for. So if there is no harm or loss, then it's unlikely that they're going to be successful in getting any compensation. So when we look at these medical negligence claims, we focus on the two elements of negligence and causation. The first question we'll always ask is, was there negligence? And the second question would be, did the negligence actually cause the outcome or harm to the patient that is being alleged? So the reasonable test that was formulated in Kruger versus Kutsia is basically a three-step test that we will always ask based on the facts of any matter that's before us. And the first would be is if the reasonable person or the doctor or the nurse in the position of that defendant, who would be your nurse, your doctor, and or hospital, could have foreseen the possibility or the reasonable possibility that the conduct would have injured the patient or caused harm, and thereby caused some sort of loss. The first test is foreseeability, and it is an important test, and you're going to see it come up a bit later on as well. The second part to that is if you can identify if there is foreseeability of harm, were reasonable steps taken to ensure that that harm didn't occur? And if no reasonable steps were taken, then ultimately you've gotten to a stage where you can prove negligence. The second leg to that is you get through your negligence query, and now you've got to ask yourself, well, we know that the conduct was negligent, but what is the link? What is the causal link to the damage caused, or the injury sustained, or the complication that is being alleged? And it's a two-part test. The first part is, but for the conduct of the doctor or the nurse, would the damage have happened in any event? And if the answer to that is, well, the conduct is irrespective, that damage would have happened in any event, then you haven't properly proven causation. And if you are able to say, yes, it was in fact that conduct that led to that damage or harm, then the second question would be, how closely linked is that conduct to what happened? And if you're able to prove those two aspects, then you'll be successful in terms of liability and negligence and causation. and you will inadvertently have proven liability. Of course, these are all the steps that a plaintiff who issues a summons against doctor, hospital, nurse, allied healthcare professional, they have to prove this if they want to be successful in their claim. Once we've gotten past the liability step, it then gets a little bit more expensive because now you have to determine, well, how much is this claim worth and how much will I have to pay? And that's when we get into quantum. So often you will find that these are the general heads of damages that are being claimed by plaintiffs. A patient will generally claim past and future medical expenses. So the past medical expenses would generally be from the time of the incident, and for whatever period of stay they had or admission in the hospital. And then your future medical expenses is now that the harm has occurred, what are the further therapies, for example, or further medical expenses this patient has to incur in terms of maybe surgeries or further medication treatment in relation to that? What is that going to look like and how much is that going to cost? So often they will do a gross calculation. And when these claims come to us, not always are they calculated down to the actual cents and rands of what is reasonable. We'll often find that they will give us a globular amount and then later on start to investigate quantum. The next part would be past and future loss of earnings. Now, if a patient came in, there was complications from a surgery due to negligence, and the patient was working and they couldn't work for a further 5 months, then you're potentially looking at past loss of earnings, which relates to the period of time which they couldn't earn. Sometimes you get a situation where they say, well, now I have early retirement and I now will not be able to work that further 5 years that I could have because of this arm or injury that's been caused to me. So then you're possibly looking at a future loss of earnings claim. And then lastly, general damages, which is always an interesting one, because it's not really based on physical expenses that you can count. It's very much based on pain and suffering, and it's sometimes very difficult to quantify pain and suffering. But our law allows for this, and so patients often, when we get these claims, general damages is almost always an inflated amount. But in order to assist us, we use case law and precedents to guide us in terms of where the courts are looking in terms of amounts. And sometimes the facts align and sometimes they don't. But effectively, you try and come down to a reasonable number when looking at your general damages. So I've included a list of experts that we might use when it comes down to quantum investigations, because particularly with your cerebral palsy matters, you will find that once you've finished and finalized your liability, quantum becomes a whole new trial, and you're dealing with effectively more or less 23 experts. But 23 experts, that's doubled because you will have the patient who will have to instruct experts to give them opinions in terms of how much, for example, if you're looking at your occupational therapist, how many occupational therapy sessions per patient may require. What are the assistive devices that they may require? In terms of cerebral palsy claims, we have the issue of caregivers that's also involved. So all of these experts provide opinions, and sometimes you might have a countervailing, sometimes you may agree with the expert. And then you'll only have one expert who's giving evidence in that particular slot. For example, life expectancy experts. In South Africa, we don't have a lot of those. So it's often you will find that parties to a claim often will use and agree to use the same expert. But this was just to give you an idea in terms of how much we have to go through in terms of evidence in dealing with quantifying a claim. And what's interesting with these claims now, particularly in the cerebral palsy context, and I like to talk about the brain injury cases a lot because they are the cases that have huge claims, and they effectively range now between 20 to 40 million rand, which is quite interesting because I think about 10 years ago, we were seeing more of these 14 million rand claims being brought. But now, with the advent of increased case law, um, and I suppose patients and the public in general having more access to the cases out there, um, you see these claims are increasing. And sometimes, when we look at patients and we are quantifying and we look at these claims, we also have to think about the reasonableness of this. And what is quite interesting is sometimes the reasonableness varies because you have to look at the condition and you also have to look at what are some of the experts saying. So I'm going to play a video for you. And this video is a cerebral palsy child for one of the matters that we had, but in this particular claim, they were asking for an electronic wheelchair, which is more on the higher spectrum in terms of costs. But once you have a look at the video, I'll explain why it was quite relevant. And there isn't any sound, so just in case you were wondering. So what is interesting, and perhaps while you were watching the video, you would have seen that the little child was able to control this wheelchair. And that's quite important in terms of how we are looking at quantifying claims and saying what is reasonable and what isn't. And what was interesting in this particular child's case, his cognitive ability was much better than most that we would see. Um, and so in his particular instance, perhaps this was something that was arguably reasonable. And a little interlude before I jump on to giving Amber her moment to shine. But often, I think a lot of people who receive claims, or healthcare practitioners or nurses, when they receive legal documents, claims, complaints, they might have this reaction inwardly or outwardly. And on that note, I think I'll hand over to Amber.
Thanks, Jenny. Do you want to give me control of the screen?
Oh, yeah, totally.
Thank you.
In the meantime, what I'm going to do is just put your slide on.
Okay. Good evening, everyone. The first topic that I would like to deal with is why is medical malpractice litigation on the rise in South Africa, particularly in the private health care sector? Fantastic. I finally have control. So this isn't just a legal problem, it's a financial problem, it's a reputational problem, and ultimately it's a patient care problem. So understanding the drivers behind this trend will ultimately help healthcare professionals, managers, administrators respond more effectively. So why do South African patients sue? Does anyone in the audience want to have a go at the answer to that question? I can't see anyone's hands or the chat room at the moment, so feel free to unmute and just give me your thoughts.
Emma, they can just raise their hands and we'll just unmute them.
Fantastic. So if anyone wants to have a go, let me know if there are any hands. I see we have a hand.
No, you can go ahead.
The question is, why do South African patients sue? Yes, fantastic. I've seen this in the chat. People are more aware of their rights. Yes, mistakes happen and are not acknowledged in time. People don't feel heard.
People have
Yes,
high expectation of the treatment. They feel the expectations are not met.
yes, expectations are not met. Fantastic.
Others can do it as well for financial gain. If somebody can convince them that you can get money from this, they
Yes,
can
100%.
sue.
Okay, no, fantastic. These are all the answers that I was looking for. So the first,
It's a way to secure compensation after harm.
yes, 100%. So the first reason that I have on the slide is that patients are far more aware and more empowered. So over the last 2 decades, patients have become far more aware of their rights. We now have legislation such as the National Health Act, which all really strengthen a patient's hand. And then you combine that with Dr. Google, as well as the internet and the headlines, such as the one that you see on the screen, as well as more accessible legal services. And you suddenly now have patients that are not only expecting more, but they also know what to do when things go wrong. And lawyers are obviously marketing more aggressively. So we have this thing called contingency fees, where it's really this no win, no fee model. And many people who would never have thought that they could afford to sue are now litigating. And because claim sizes are so high, lawyers are willing to take on these cases. So we have this combination of greater awareness plus easier access to lawyers, which ultimately mean more claims. So the second reason is one that you may not have thought of, and it's that the legal and insurance landscape has changed. So historically, many personal injury lawyers focused on motor vehicle accident claims through what we call the Road Accident Fund, or RAF. But the RAF became a lot less profitable for lawyers after multiple reforms, so many of them shifted their attention to medical malpractice. The reason being that they both deal with personal injury claims, but it's not as simple as that. But in any event, the result is bigger claims which happen more often. Some interesting stats actually, and Jenny was touching on this earlier, but between the year 2008 and 2013, claims over 1 million Rand rose by more than 500%. Claims over 5 million Rand rose more than 900%. So, I mean, that's overwhelming growth. So we have this vicious cycle. We have more claims, which lead to higher insurance, which lead to higher healthcare costs, which ultimately put more pressure on the system. So the third reason I want to touch on is clinical issues in private hospitals. So if we're being honest with ourselves, not all of this is some sort of patient perception. There are at times real quality issues at play. and that's even in private hospitals. So there are alarming malpractice trends in private facilities, which now include failure to follow protocols, poor patient monitoring, medication errors, and quite frankly, inadequate training. And these aren't just minor slip-ups. These are failures that can lead to catastrophic outcomes. So litigation is rising partly because patients are right. Errors do happen. And when those errors aren't acknowledged or managed openly, the courtroom will ultimately become this arena where patients will seek some sort of compensation. So, to recap, why is malpractice litigation increasing in private hospitals? Patients are obviously more informed and empowered. Lawyers are more focused on the space. Claims are bigger and more frequent. Insurance pressures have become immense, and quality of care issues are very real. I want to take us through some real life case scenarios, or what we've called case studies, which will hopefully bring a lot of what Jenny said during her overview this evening together. So the first case study is what we have called the wrong blood transfusion. So these are the facts. A patient was admitted to a private hospital for an elective surgery. After the operation, she required a blood transfusion. The nurse received the blood from the hospital's blood bank and proceeded with the transfusion. However, the blood bag actually belonged to another patient with the same first name, but a different blood type. Within minutes, the patient had suffered a severe reaction, which led to multiple organ failure. She survived, but she ultimately suffered with long-term kidney damage. The patient sued the hospital for damages. So knowing what you now know, who do you think would be liable in this situation? Any takers? I can't see the chat if anyone wants to. Hospital and the nurse, okay. The nurse, I'm getting the nurse a lot, yes. The nurse and the hospital, yes. Okay, fantastic. So we're all on the same page here. But let's do a quick legal analysis using our 5 elements of DLEC that Jenny ran through. Okay, so can anyone remember the first step in this? And I'll give you a hint. It starts with a C. Okay, not causation yet, but well done to whoever mentioned it. Okay, contract. Remember, we're focusing on dialect here. Okay, so the first step is to establish if there's some sort of conduct. Yes, someone's just said conduct. Yes, well done. So ultimately, the conduct here would be the nurse failed to verify the blood type and the patient ID before the transfusion. The second step would be to establish if there's some sort of wrongfulness. So there's a clear legal duty and I suppose ethical duty too to ensure that correct patient identification and compatibility. The third element is fault, and like Jenny has said, our focus is on negligence. And here the error fell far below the standard of a reasonable nurse. A basic verification step was obviously missed. The fourth step, and someone said it in the chat, well done, is causation. So in this matter, the transfusion directly caused the organ failure. And then the last step is to establish harm. So again, in this case, the permanent physical damage and loss of her health was the harm that was caused. So in this matter, and I think that there were a few people that touched on it, ultimately the hospital in a civil matter would be found vicariously liable for the nurse's negligence because it occurred within her course and scope of employment. Okay, so the second case study, which is what we have called the delay that did not change the outcome, the facts are that there was a young woman in her mid-20s who arrived at a hospital complaining of severe abdominal pain and fever. She was examined in the casualty ward, but due to staff shortages, and I suppose it was a busy night, her treatment was delayed for, I want to say, several hours. When she was eventually attended to, doctors diagnosed a ruptured appendix with sepsis. So she was taken for surgery, but developed complications and was left with long-term digestive issues. She sued the hospital and the doctor, claiming that the delay in treatment was negligent, and that ultimately caused her complications. So let's do another quick legal analysis using our 5 elements. Can anyone remember the first element? I'll give you a hint again. It starts with a C. Yes, fantastic. Conduct. Okay, great. Okay, so the first element is conduct, like everyone is saying in the chat room. The hospital delayed attending to the patient. What would be our second element that we need to consider? Anyone remember? Yes, fantastic. Wrongfulness. So the second element is wrongfulness, and there was a clear duty here in this case to provide timely emergency medical care. The third element, anyone? Fault, yes, fantastic. And we specifically focus on what aspect of fault? I know someone's got it. Yes, there we go. Negligence. Okay. So the court accepted that the delay was negligent. Reasonable hospital management should have ensured earlier assessment and intervention. However, when it came to causation, which is our fourth element, medical evidence actually showed that by the time the patient had arrived at the hospital, her appendix had already ruptured. So the infection and sepsis had set in hours before her admission. So that meant even with prompt treatment, which she didn't receive, the same complications were likely unavoidable. So in other words, the negligent delay did not materially worsen her condition. And the outcome was that the court found that negligence was present, but causation was not proven. So the plaintiff failed to show that the delay, as opposed to her underlying medical condition, caused her long-term harm. And ultimately, the claim was dismissed. Okay, so I want to take us through some real-life examples that have actually been decided by our courtrooms. So the first case that I want to focus on is the Michael versus Linksfield clinic case, which is a 2001 case. It's quite a tragic set of facts. A 17-year-old boy underwent corrective nasal surgery at Linksfield Clinic in Johannesburg, and he suffered cardiac arrest while under general anesthesia. By the time the resuscitation had actually restored his heart function, he had unfortunately sustained major brain damage, and he was left in a permanently vegetative state. So, I've gone one slide too far, my apologies. The allegations of negligence against the clinic included the failure to have functional resuscitation equipment immediately available and failure to train staff on its use. So we know that something went wrong, and the patient went into cardiac arrest. Now, what do we expect in that situation? Well, we expect the medical team to know exactly what to do in that situation. But here's what happened. The nurse didn't know how to use the resuscitation equipment properly. And the court emphasized that it is not enough to be present in an emergency situation. A nurse needs to be competent in the tools required to save a life. So the court found that although there was ignorance about the resuscitation equipment's display, this did not materially delay in the resuscitation or actually affect the outcome. So again, there's that interesting play on negligence and causation. So this means even if a tragic outcome occurs, liability will depend on the medical professionals or whether they acted reasonably according to the accepted standards, but also whether this negligence actually caused the harm. But the lesson I do want you to take away from this case is that competency is a legal duty. So if you or your team do not know how to operate equipment, ask, train, escalate this. In court, unfortunately, I didn't know is never a defense. So the second case is also quite tragic. And I've put the judgment on the screen. And the opening line of the judgment reads, while part of the world celebrated Christmas for various reasons on the 25th of December 2013, a young boy's life was destroyed by the negligence of medical personnel. So in short, a mother went into labor at Netcare Femina Hospital on the 25th of December 2013. The nurse monitored her, but obviously not carefully enough. And the fetal heart rate was dropping, and I think there were clear signs of fetal distress. The nurse didn't escalate these concerns quickly, and when she did, her documentation on the matter was poor. So I've gone too far again, my apologies. So the court found that the hospital's nursing staff failed in several respects. They ultimately did not monitor the fetal heart rate as required. They did not keep proper records. They did not investigate or act on signs of fetal distress or vaginal bleeding, and they did not timeously call for medical intervention or arrange for a C-section. So the court found that these failures were the sole cause of this child's brain damage. The court, interestingly enough, though, didn't find the obstetrician liable. I think they noted that while she wasn't present during that critical period, her actions, although they were subject to some criticism, did not amount to negligence. So the key takeaway here is really that proper monitoring, record keeping, and ultimately timely intervention are critical in providing healthcare. So documentation really shouldn't just be treated as admin. It ultimately can become evidence that saves you in court. And unfortunately, if it is vague, a judge will just assume that you didn't do your job or ultimately it didn't happen. I'm going to hand back to Jenny. I think she's going to run you through 2 more cases after, or now.
Thanks, Amber. I'm going to ask Sam to please assist me with my video. But while we are on that,
I think you should also take away my control.
Okay, so whilst we're waiting for that, the next judgment is thanks, Sam. So the next judgment is PM on behalf of YM, and I've taken out the names for obvious reasons, but effectively, this was a very, very interesting case. And the reason why it was so interesting is truly because of the facts and the factual evidence that had come through in this particular matter. So, in this particular matter, the mom was 29 years old. She was a primigravida, pregnant woman who came to the hospital because she was referred for monitoring of her blood pressure. And effectively, they just wanted to ensure that she did not end up in a state of preeclampsia. And so while she was being monitored, etc., as it were, her memory spontaneously ruptured, and then she was in labor. But what happened thereafter was the doctor and the nurses advised her an emergency C-section is required, and so she was eventually taken to theater. The baby was born with a hypoxic injury, and the reason for this is that there was a delay in the time from her being in labor and being ready, fully dilated, ready for between the time of her being in labor and then getting into having an emergency C-section done. So the interesting point about this whole case was really the mom's allegation was quite severe against the staff and the conduct of the staff. And she alleged that, firstly, the nursing staff failed to monitor the fetal heart rate, so they didn't pick up in time that the fetus was in distress. They failed to administer misoprostol, and they failed to perform the cesarean section urgently. She also made further allegations about the fact that when she was being taken to theater, she was being dragged to the theater, she had to walk, and effectively she could even feel the bearing down before she got to theater. And the opposite to that version was the evidence that the nursing staff, the doctor, and even the anesthetist gave, all of which were called to give oral evidence during this trial. And the nurse had said, we tried to assist, we tried to monitor. The problem that we had with this particular patient was she was so difficult. She absolutely refused for us to conduct the proper assessments. She refused for us to monitor the fetal heart rate. She refused to listen to the advice that was given to her in respect of the risks of her failing to be monitored, and also just listening to the proper management and care that they were trying to give her. And she simply refused the C-section. And that was quite interesting because normally in these types of cases, you often see there's a heavy emphasis on a lack of monitoring or a lack of picking up that the fetus is in distress. And here you had an instance where the mom simply refused. She was actually quite aggressive, and in one instance, she attempted to bite the nurse and was successful on one occasion. And the doctor had advised her of the risks of failing to have the C-section on time. Even the anesthetist would remember how vulgar she was during this whole process. And it really boiled down to the question of, well, this is a refusal of treatment, really. And now we're looking at not so much negligence. Now we're looking at also the conduct of the mom, and we're looking at patient autonomy. And so the court had an interesting way of looking at this because despite the fact that she gave some very sympathetic evidence, the reliance from the court side was on the medical records. And what the nurses and the doctor had done was there was a recordal of every time there was difficulty with this patient, every refusal that she did, every issue, every delay that they experienced. And whilst a lot of things were happening at the time, ultimately, 3 years later, these nurses and the doctor documenting this was ultimately what landed the defense for this case. So the court took into consideration the oral evidence and took into account the recordals, the notes, and ultimately decided that the plaintiff hadn't proven her claims. She hadn't proven negligence and certainly hadn't proven causation by falling off that point of not proving that the hospital nurses, the doctor failed to properly provide her with proper management and care. And it's a very interesting case, particularly because it also looked at the constitutional aspects where patient autonomy is also looked at. And a patient has a fundamental right to refuse treatment. And in this instance, she didn't get away with using that as a reason for saying, well, the hospital staff, the nurses, the doctors, they're all negligent. And now I have a child who has a brain injury. So this informed concept is very important as well because a lot of emphasis is placed on doctors and nurses making sure that potentially more doctors in certain circumstances on obtaining informed consent. And what is so important about it is often you'll find healthcare practitioners finding claims against them where the patient says, well, I wasn't properly informed of the risk. The doctor didn't explain to me what the proper complications of the surgery would have been. And the interesting point about this case was it flipped that. And it was what happens in an instance where you are informed and where you choose to then accept the risk by refusing the treatment. So it was almost a principle that came out of this case where it extended the issue of informed consent and informed refusal, which was a very interesting case. And I think for those of you that find difficulties with patients, particularly I can understand sometimes in the labor ward, often I find the nurses saying to me, patients are difficult, they just don't want to listen to me. And you have to deal with multiple patients in these circumstances. I think the key takeaway for this part in terms of that was noting it down, documenting it properly, because you never know down the line, how many years down the line also this might come up. And if a patient refuses treatment, document it down, even if they fail to perhaps even sign to say I'm refusing treatment. Later, it will come up if it's ever in a case or a claim. And so it might be the saving grace in that instance. The last case that I wanted to discuss was Du Plessis versus the MEC for Health. And it was an interesting matter because a patient came in with complaints of diarrhea and they treated him. And during his treatment and care, an IV drip was being inserted. And as luck would have it, a piece of the IV drip broke during the insertion. Effectively, he then had to go and have surgery. And when he was brought back, he said, I don't understand why they would use this faulty drip. They knew that they were using a faulty drip and they used it anyway. And now I'm a boilermaker who can't use his arm anymore. And the interesting point about this case was that on the face of it, some might say that was negligent. Obviously, using a faulty drip causing harm to a patient who now can no longer do his job may be considered negligent. But what was interesting about this case was the court took it a little bit further in its investigations. And when it was going through the issues of negligence, looked at the first part of foreseeability. And the question really arose was whether or not the nurse could have reasonably foreseen that this particular drip was faulty. And the answer to that was no, she had no idea. It hadn't happened prior, and I think it would have been a very different situation if it had been something, an incident that happened before. It was the first time it had ever happened. Um, and so ultimately, the court found that they weren't liable and dismissed the plaintiff's claim. He eventually took that up on appeal, and even on appeal, it was dismissed again. And it was a very interesting case to see how the elements of negligence was looked at from a court's perspective. And even with the issue of foreseeability, the court was able to look at the reasonableness. And reasonableness always pops up when when courts are looking at negligence, because they always want to know, was the conduct reasonable in the circumstances? Did the doctor act reasonably? Did the nurse act reasonably? And once you're successful on these elements, um, then it's unlikely that a claim against you would be successful. So I hope that you've enjoyed the case studies that we've mentioned and the case law, and that you have obtained some nuggets of information from us. And now we will open the floor to questions.
Jenny,
Hey, Jenny, Amber. Yeah, is there anything else you'd like to add, Amber?
yeah, sorry, Burton. I had a quick look at the chat room prior.
Yep.
And the one question related to resourcing limitations, and I think it related to the ruptured appendix case. So I just want to quickly touch on that before we have a look at the further questions. So resource limitations don't automatically, I want to say, excuse negligence. Remember, we need to go back to our overview of negligence and the legal question behind that, which is ultimately, did the hospital take reasonable steps within the available resources? So if the delay was per se unavoidable despite these reasonable systems in place, liability may not follow. But if the delay resulted from poor planning or if there was a failure to follow some sort of protocol or even, I want to say, understaffing, then resource limitation is unlikely to be a defense. So a court is likely to make that distinction. But great question.
Yeah. And I think just to add on to that, we see a lot of it in the public sector, claims brought against the MEC for health. And what you find ultimately is you do find that the nurses or the doctors raise the issue of resource limitations. Unfortunately, because of way these claims work, the MEC for health, for example, as a defendant, holds that responsibility to ensure that resources are there in the hospitals. And talking about vicious cycles, I think, when you see the amount of claims that are paid out, ultimately it affects the hospital's budgets. So it just decreases their budgets and their resources in any event. So it's a little bit of a catch-22 when it comes to those public sector matters, I think. But ultimately, yes, I agree with Amber. It's not really seen as a defense where, at least I haven't seen the courts take it into account. Sympathy, perhaps, but definitely not from a liability perspective. I see there's a question here that says, in the public sector, most patients pay 0 cents. How do they claim for past medical expenses? And also for future medicals, as they presumably would use the same public facilities. Quite an interesting question, and I suppose a two-parter. So correctly so, you could say that they didn't incur any past medical expenses. But sometimes during the course of the period from the incident happening all the way to them having a summons issued and eventually having litigation kick in, you may find that they are, for example, receiving therapies where they might have paid a little bit of money for it. Sometimes family members assist and then they get help with making payments for these expenses. Generally, I have to say, past medical expenses isn't the usual route that you would find for your public sector claims because of the exact reason you've said. But we do see it come up a lot when you have your cerebral palsy matters, where it takes almost 10 years before liability in some cases is ever decided. And in that interim, the patient has to receive therapies, medication, treatment, sometimes surgeries, and these can rack up and form part of your past medical expenses. In terms of the second part to that question was future medical expenses, as they presumably would use the same public facilities. Now, ironically, you think they would, but when lawyers get involved, sometimes they're advised not to use it, not to go to the public sector hospitals. And sad to say, but they do get funded by their attorneys to receive private sector work, treatment in the private sector. And so that forms a basis for them to save future medical expenses as well. And ultimately, look, when it comes down to it, it is unlikely if you have a payout of 3 million, 4 million, you're going to see a patient say, yes, I'm going to go to the government facility. Suddenly they're going to say, no, I want the best care because of the damage that was caused to me.
Hi, Jenny,
I
Amber.
hope that helps.
Yeah, thank you so much. For our colleagues that joined after the introduction, we have Jenny Govender and we have got Amber who are joining us from Norton Rose, Fulbright, South Africa. And so they are practicing dispute resolution, litigation attorneys, focusing on medical law and professional indemnity matters. And so they represent one of the departments of health sections, as well as doctors and nurses. So thank you for joining us this evening. There are a number of questions that are posed here. Amber, one of the ones I like, normally the questions are posed to you, the presenters, but you are also keeping everybody awake and on their toes. And so some of the interesting, just so you don't get away with anything, when you asked about why there's an increase in a spike, it said that there are people that don't feel that they're always heard, and sometimes for money or poor communication. And then here come lawyers, because you're here now. Lawyers have identified medicine as a lucrative market. And then also sometimes misleading by lawyers with staff attitudes, poor communications, again, patient feeling betrayed by the people that's supposed to help them. And then some are convinced by staff or even their colleagues to go ahead and do this. But interestingly enough, you showed this video of Macaulay Culkin screaming when he saw, said he was home alone. But in the case of any one of our healthcare practitioners and colleagues here, when they receive a letter of demand or a summons letter, could you please advise them what not to do the minute they receive that letter of demand, in terms of flippantly or without consideration, quickly jotting a response to the attorney that sent it, and what would be the next best step for them to do once they've received that summons or that letter of demand?
Thanks, Burton. Jenny's actually just published some sort of, or I'm going to say, if you can call it an article on this. So I'm going to hand it to her because she would, she's obviously.
Well, can I just say the first point is please don't ignore it. It's not great to receive one, but you certainly have to deal with it. And it has a lot of, it can have some complications from professional point of view as well, employment point of view as well. So there's a lot of consequences. And the best course of action, I would say, is please do not respond to an attorney on the other side and say, I did this and I did that, or I didn't do this. The first course would be, highlight it if you have a professional indemnifier, which I assume that most of the healthcare practitioners will be aware of on the call. Inform them. Early notification is always good. And perhaps, once you receive that letter, read it, understand what it is that's being alleged. And a practical tip would be sometimes you may not even recall this patient, quite honestly. I mean, healthcare practitioners see thousands of patients. A good idea would be just well informed, your professional indemnifier and management, hospital management also. It's always good to inform them as well. And then you start the process of getting legal advice and legal assistance. What you do is you try and collate the records, go back, look at the patient file if you have it from a doctor's perspective, from a nursing perspective. Maybe you want to just have a look at the hospital file. But the point is to try and create some sort of chronology, even, because memory fades. And whilst you might also receive this 3 years, 4 years, 5 years, sometimes 10 years later, the litigation process in itself is also long. So try and write down as much information as you can. And I think that's critical. But there are, you have the legal assistance for a reason. So I'm going to say, please try and rely on them before you try and interact with a patient. If you are receiving a letter of demand or a complaint from a patient, please don't then pick up the phone and say, I know this patient for the last 10 years and I'm just going to discuss this issue. Sometimes it might not be the best course of action. And what you perceive as being a good relationship may have been broken down by that time. So that's my little tidbits of information.
I think,
Yeah, I think, sorry, please go ahead, Amber.
sorry, Burton. I think, Jenny, what we should also do following this this session, I think we should send out that article that you've written, because it really just concludes all those points so beautifully.
Yeah,
That is good.
I'll be happy
Yeah,
to
and
share
before
that
I
with
go
you.
into, thanks, Jenny. Before I go into more of the questions, when a family walks into your room, into your practice, into the hospital environment, sitting with the hospital manager or the management team, anybody related, what is the nature of that? And they have a complaint, right? So they complain about negligence, or they're not happy about treatment of themselves or a loved one. What is the nature of that conversation like? I know many times they want to record the conversation, or they want the hospital to submit reports or hospital records. What is your advice around them and acknowledging failure to meet maybe their expectations, or saying that we didn't meet our own expectations? What is that conversation is like? Because invariably it ends up what we say during those sessions, that it comes out through the attorneys afterwards.
I'm
Yeah, I
happy
mean,
to
I
take
think in,
that
go for it, Amber. You go.
recording part. When you are speaking with someone who feels that they have done wrong, the first thing that you need to know is that you cannot admit liability. There are ways of apologizing which we say are or considered to be legally safe. The catchphrase that I want you to take away that you can say to a patient who is complaining or has this complaint, and it's very simple. I am sorry that we did not meet your expectations. This matter will be investigated. Again, what that does is that it shifts the focus onto their expectations in the matter. So their expectations may not have been reasonable in that situation. And again, when we go back to our test or our legal test that Jenny's touched on, we have to focus on the reasonable person. Jenny, I don't know if you want to handle the recording of it?
Yeah. Look, I think often you want to be careful from ever saying, I am at fault. I accept that we have done something wrong. And also we were negligent. Don't ever use those words. I think they latch onto it very quickly. And, when we get to the stage of actually investigating, you realize perhaps there wasn't any misconduct here. Perhaps the circumstances in this particular case, acting that conduct was reasonable. Um, so in terms of recordals, look, they're not supposed to be um, recording you, and obviously um, that is something to subject to you consenting to being recorded. If you consent to the conversation being recorded, that's a different story. But ultimately, I would say try to have something where it is, we often refer to it as a without prejudice discussion. And I see sometime hospital management, they do that. They have minutes that are recorded and also agreed upon. So that later on, when it does, and it may well eventually become a claim, you have a minuted discussion that both parties know exactly what was discussed. So you're not going to have this issue of, well, you said you were wrong and you utilize the discussion, but and it's a way of protecting one to ever be in a situation where you've already lost the fight before you can start effectively. I think, yeah. And remember, when we're talking about these aspects of reasonableness, please remember that there's no gold standard to this. There are protocols in place, there are guidelines in place. The regulatory bodies provide guidelines to you as well. That's the reasonableness and standard you have to keep up to. It's not some golden standard. So it's very easy in these circumstances when things go wrong that we sometimes forget that because we always take a very sympathetic approach. But remember, reasonableness is reasonableness. It's not some golden standard. And you often will get the question, did you act in accordance with what another reasonable practitioner or nurse in your position in those circumstances would act? So yeah, I think that's just something I wanted to touch on because I know we're talking about reasonableness and the reasonable test, and sometimes we just don't remember what that means.
So what happens when a doctor gives a certain drug, gives the wrong dose, then orders it, the nurse administers this dose, and the patient complicates? This is a question coming from the panel. Then in that case, where does the liability fall?
Happy to take this one. So to qualify it, if the prescription was clearly wrong and the doctor insisted, the doctor therefore is likely to be negligent for prescribing incorrectly. But a nurse cannot just sit back and be sort of what I want to call perhaps a passive witness to these instructions and carrying them out. If the dose was obviously unsafe and the nurse knew, then the nurse may also be negligent. If the nurse raised it with the doctor and the doctor insisted, then I want to unfortunately say, at least in the private healthcare sector, the doctor is considered what we call the captain of the ship.
Mm-hmm. And then what recourse is there in a situation where a parent denies care to the child by signing RHT, right? Refusing hospital treatment on behalf of a 2-year-old, for instance. What can doctors and nurses do to mitigate this, or how can they assist the child?
I think it would really depend on the situation and seriousness of the treatment that is being denied. I think that's the first aspect that you would have to look at. If it's not urgent treatment and care, then it's often the best way to deal with some of these situations is having what I'd like to say is it's a bit of counseling, but good counseling with the parents and making them understand the necessity of the treatment, understanding exactly the scenario may well do away
Hey, Jenny, your line seems to be
this
breaking up a
issue
little
of
bit
them
choppy at
refusing.
the moment.
The refusals
Jenny?
might be religious in nature, related to religious reasons. And, you know, in those circumstances, there are recourses because ultimately the High Court is the overseer of all children, minors, and there's a way that we would end up taking an urgent application to ensure that the child does get treatment. But it would really truly depend on the type of treatment and the necessity of it. But often you find having clear communication does help, and it's a way of mitigating issues that may arise.
So there are so many people that are saying thank you for the informative presentation, and you can see them in the chats. I know that the two of you are following those, but there are some pressing matters here. Somebody's saying, is it legal to offer employment of a relative as compensation for loss of life of a family member? So before you answer that, there's also a question about one of the cases with regards to the MEC. So there are some probing questions as related to that. So perhaps you want to forward your slides to that one. But yeah, you're hiring a family member, somebody's passed away, and compensation.
I don't think our law would recognize you giving some employment as compensation. I mean, I don't know to what extent that would also be accepted, and I'm just wondering if I understood this correctly. It's a form of compensation by giving employment to a relative.
Yeah, seems like it, yeah.
Yeah, I must say it's a very interesting scenario, and I can't I can't imagine that that would be a legal recourse. But I mean, certainly if the person wants to work for you and has a different, if that pathway of getting the employment is different and not based on the fact that you simply harmed a patient who's now passed on, then that might be a different scenario. But I think as actual compensation, I wouldn't agree with that being very ethical either. So
Yeah,
that's
Jenny,
my standpoint at the very least on that.
I'm getting quite a few responses and pushback from nurses saying that as a nurse, I am allowed to refuse to give a wrong dose. And me and the prescribing doctor, they can engage with a senior doctor for clarity. So there are more and more, I see quite a few sort of opinions around that, where they say nurses saying, no, this, they know that it's wrong. They are not going to be going forward with regards to that. What I do want to go back to, though, is that case around the MEC. The question was,
Mm.
how was the case handled with the refusal of care resulting in harming the fetus? Is there a claim? And a related question earlier on was, what about the fetus? The mom refused treatment and there's a complication on the child. Is there any form of right that the child has in this matter?
That's a very interesting one, and I foresaw this question coming at some point. Um, but what is a very interesting point in our law is that a fetus is not recognized as a legal person in our law. And that goes back and it reminds me to my days in law school, having this discussion with the lecturer and saying this is absolutely wrong. But as the law stands, a fetus does not have legal rights, so there's no true legal recourse. So whilst you are correct, the fetus did inevitably have harm, and to some extent, and perhaps to a majority of that extent, it relates to the fact that she refused to have the treatment. The difficulty with that is there's no legal right, and without a legal right, you cannot have locus standi in order to bring a claim. So that is what creates an issue from the fetus's point of view. So you only get your rights once you are born alive, and alive means that when a baby is born, is breathing. So yeah, that's something interesting just for you to know as well. So unfortunately, no.
I just wanted to make you aware that your principal is here on the line with us. So I've got what's this Yash Naidu saying, well done, ladies, from a former NRF lad, regards to the Nero over there. So what actions to take or handle if patients' relatives are misbehaving towards, for instance, if they've lost lost one, despite the quality of care given to their relatives whilst in hospital was good. In family, you see this quite often, right? We've sat on panels where we're discussing these difficult matters. So how do you handle difficult family members?
I'm happy to take this one. Following the death of a patient or a family member, grief obviously follows from that, and I could imagine it would sometimes present as anger. I would say that your immediate priority would obviously be to de-escalate the situation. So I would respond with empathy, perhaps not defensiveness, and then offer some sort of structured meeting to explain what happened, and do that in the presence of someone more senior, so in the presence of your manager, for example. Also keep documentation of all of this. And then if the behavior, I suppose, becomes more threatening, hospitals obviously have security on site. Don't confuse quality care in the sense that that doesn't really eliminate some sort of emotional reaction. But transparent communication and communication that isn't delayed often prevents that escalation to litigation, or at least the litigation stage.
Yeah, Amber, Jenny, I think just from an interesting thing, as I said, other platforms that we sit on, is there a time where legally something that happened to a patient is seen not to be illegal, or the providers being found at fault, but from a clinical professional point of view, the practitioners or the providers of care were seen to be at fault, so that so it's not always cut and dry that if something happens clinically, that there was failure there that led to a negative outcome, that it doesn't necessarily result in a legal liability to the provider.
I think, and if I kind of understood the question correctly, Burton, you're asking is there an instance where even if the conduct was done where there isn't any sort of wrongdoing, etc., some harm is caused eventually, but there's no negligence or liability that's attached?
Yeah, so
I
yeah,
think
so from a legal point of view versus a clinical conversation.
I think there are instances. I think there are instances. Look, like for example, you see it a lot with known complication and risks that occur with sometimes instances where complications arise, but not necessarily due to any clinical misconduct or any negligence from a clinical perspective. It may well just be the circumstances of a case because somebody did something wrong. Sometimes that does happen, and it may not even occur due to an error. Clinically, sometimes the practitioners could do everything right from a reasonable point of view. You could do everything according to what you've learned and your experience, and you could still find yourself in a situation where a patient dies. Um, Unfortunately, these things do happen. When you're looking at these instances, you know, you go back to the question of reasonableness and was everything done reasonably within the circumstances? And if the answer to that is yes, then it is unlikely that despite a terrible outcome, um, it is unlikely then that you would find somebody being found liable. And I hope that that sort of assists your or answers your question, Burton. But is that something that answers it?
Yes, thank you very much, Jenny. Again, a lot of appreciation here. Dania, one of our colleagues at Clinix Healthcare Group, is asking, but what about the pharmacist? So the dose is wrong, or the doctor insists on it. So what about their liability by offering and issuing the drugs? We can't leave the pharmacist out of the continuum of care chain here.
Okay, we're so sorry. We didn't mean to. I think I read the question earlier, and it was specifically where the doctor requested that dose. So, I mean, I would say, just as in the situation with the nurse who said to the doctor it was the wrong dose, I think that liability would likely attach to the doctor in that situation if the doctor's requesting the wrong dose. That being said, it's unlikely that the pharmacist will actually see the patient to make an assessment. And again, it might not be in their realm of what a reasonable pharmacist would be expected to do in those circumstances.
Amber, while you're there, from time to time, a patient will consult their attorneys and they're about to sue, they're looking to sue a colleague of yours. When I'm saying yours, meaning that you're a healthcare provider and you receive a phone call from the attorney of this patient and looking for information which could possibly be used against your colleague. And I think that's what our colleague is asking you on the question in the chat. So what do we do in instances like that?
I would advise not to give out that sort of information. We also have to take into account certain laws and POPI especially nowadays, but I would not advise to proceed to hand out any information on a case that you may know in those circumstances.
Well, many times doctors tell patients, please come back in 2 weeks' time. So one of the questions here is, again, where they say the doctor has no idea what's wrong with the patient, but keeps saying, come back for more therapy and treatment. Is there some ethical, is there something from a legal point of view that is inappropriate about that management?
It sounds like you need a different doctor.
I was about to say perhaps a second opinion.
Yeah.
I think that if there's circumstances that prevent you from getting a second opinion, let's say, I would proceed to return, because again, you don't want to be criticized for not following up on a scheduled appointment with the doctor. That may be raised as a point against you should you pursue some sort of recourse against that doctor in future. But I would focus on getting a second opinion.
I think what's crucial
And I would
here,
also probably
yeah.
communicate that,
Yeah.
say if you are disgruntled as a patient, then say to your doctor, I don't actually believe that this treatment plan is working. Can you just make me understand it? And often you'll know, because if they're fumbling and they can't exactly say to you, this is the plan, this is where you should be seeing your progress, etc., you may want to then say, okay, well, I've tried. Now I'm going to go to somebody else and get a second opinion. I mean, that might help as well, just from a practical point.
The last two questions, and I think this one is a critical one. How long does a family or patient or their attorneys have before they can actually, or the litigation expires whereby, how much time frame do they have? Is it 5 years? Is it 10 years? Can they pursue you 20 years later, for an instance? And we kind of links into keeping patient records on file, and for how long do you keep those records? So those are kind of, I think those are pertinent questions.
So we have an interesting concept, which is known as prescription. And what this means is that in general, for example, if you have a patient who's an adult who somehow there's a complication and they want to pursue a claim, the expiration to that is 3 years. And if you have, for example, a minor child, so say, for example, you have in your cerebral palsy matters, in that regard, you may well receive a claim 10 years later, 15 years later, and I must admit I've literally have come across a few of them where it's 10 years later, 12, the child is age 12 sometimes age 14. And in those instances, it doesn't prescribe, they do not have the prescription doesn't apply to them the same as it would to a normal, competent, mentally competent person as well. The difference of up until the age of 18 years, where we are considered adults in South African law, up until that point, the claim will then be brought generally on behalf of the child. So it will be the legal guardian or parent who will bring that claim. And thereafter, usually you'd get a curator who's appointed to act on behalf of them. But generally, in those types of claims, you're not going to see them prescribing. But as on a norm, where you do have mental competency and it's an adult, you're most likely only going to see 3 years by which you have to bring that claim.
And then,
So they have 3 years from date of incident.
Okay. So in a case where a patient demises, and again, this is a relevant question in terms of dealing with an incident that just took place, right? So family comes in and you have the sit down, and so hospitals are often quick to do what we call a root cause analysis, all right? So you want to quickly do an RCA, and by nature, an RCA finds fault in some way and make recommendations. Are those records are they supposed to be, or could the family request those records for their own purposes and possible litigation later on? So maybe just a caution and guidance around that one. This is your last one, so please answer well.
So, look, it is often the case that when it comes to a claim stage, these documents are requested. On general, I wouldn't advise to simply hand it over. It is best to discover, as we would say, or disclose these documents when you know for sure exactly where this is going, because often you'd find in these incident reports, you would literally say that the nurse, for example, was disciplined or dismissed, or something was doctor-related incident, or it's always err on the side of caution from that perspective. And if they want to litigate, then there's recourse for them to get access to it. But yeah, I wouldn't generally just simply say hand it over. I mean, I assume that they would go through the proper channels in requesting it, in which case you'll have to comply. But certainly simply handing it over is potentially not the way to go. I mean, Amber, I'm not sure if you have anything to add on that.
Yeah, I definitely wouldn't just hand over any sort of internal hospital investigation report. We don't include those in discovery or when we get to discovery stage. Like Jenny said, if you're not at that litigation stage yet, then I would suggest that the patient's family make a request via the hospital for those records. There's often a form that they would have to fill out, giving their reason, giving their relation to the person who they want the records of. So all of those things need to be put down in writing and sent to the hospital. The hospital has a certain period to respond to that. They may ask for further information from the patient's family, or they may be satisfied with what is recorded on that form already, and then they will be entitled to the patient's medical records.
Yeah, I promise this is really the last one. There's this conversation around legally having a folder on your desktop, legally privileged and confidential. What is the significance of that? And you know what I'm referring to.
So the legal privilege, often we would refer to it as, for example, when we are discussing between, say, Burton, you and I are having communication, that we would say, if we are investigating the claim and we're discussing it and the merits around that, that would be legally privileged, which is between attorney and client sort of real relationship. There are different aspects to privilege, and sometimes if it's waived in certain instances, you can't rely on it. So say, for example, and this is a typical one that we see when we are investigating and there's a report. Sometimes we get internal reports, or as you would know, Burton, like the risk committee reports that we get, or, sometimes you just want to get an opinion from an expert. And say, for example, that expert decides to disclose all the documents that you provided to them. And you decide, okay, this expert is fine, this expert opinion is fine. I'm going to deliver it to the other side to show them, look, nothing was wrong. That might become then something that you've waived your privilege to that kind of document. So in that instance, you just want to be careful about that. And I think the same applies for even reports that you may have. One expert referring to another expert report that you haven't delivered. And then suddenly all the reports become discoverable. So you have to deliver them because you've waived that privilege. There are nuances to privilege. And I think generally the discussions that we have, it would also be the communication that we have. And on the flip side to that, the patient and their attorney, the stuff that the advice that they're getting, internal discussions, that's also something that they will say, I have legal privilege, you're not allowed to look at this. But yeah, I think, I don't know if Amber wants to add anything. I like the privilege arguments sometimes.
Just call us if you have any sort of and just pick up the phone and ask us, and then we can guide you accordingly. I think it'll be document specific too, but don't
I've got Deirdre now asking because Heather had asked a question earlier on, and I think there's an insistence here. It says, when it's about money, would refunding be the simplistic, or would it be seen as admission of guilt? Example, when a patient who has a long labor, which ends in a cesarean section, then they want their money back from the midwife who didn't deliver the baby. In that case, would that be seen as some level of admission of guilt?
I think on a general aspect, yes, that would. I think it's just how we perceive it, right? It's about perception and the impression that comes from that. I think automatically when you decide to say, yes, sorry, here's some money, the impression is I've done something wrong. And particularly when it comes to these birth injury matters or anything related to obstetrics, I don't think you want to be in a position ever offering money. Because it also opens the door for you to be further exploited, and at which point does it end? So yeah, no, that's something that is definitely not an avenue I would advise. And I suppose it's a different situation if you're engaging in without prejudice discussions, and there's an interest to try and resolve a claim, for example, and you say, well, it makes commercial sense, I'm going to give you an ex gratia type settlement amount or payment. That's a different instance, but simply saying here's some money because something's gone wrong, I don't think that's the way to go.
Any, Amber, There are, I'm sure, other questions that are here, and we will pose those to you. I'll send you an email with all of those. I just want to say thank you so very much on behalf of the Clinix Health Group, who sponsors these webinars every Thursday, as well as all the attendees. There were over 700 people here listening to you this evening. So feel free to go and share that with your directors and partners. So we're really proud of you, and I'll be sure to send a note to them for you. And I know I kept you away from your dinners and your families. So again, from all of us, thank you very much. You can see the heart flowing. They're all coming in your direction. As a motivation for all of those, and I shared it earlier on with Amber, there will be a special gift delivered to your offices. So for anybody else that would like to participate and present at these webinars, all our colleagues that are still on the line, thank you so very much for attending and staying to the very end. Sam, I know it's difficult behind the scenes there, especially with the webinar network and the arranging and the organizing. So thank you so very much to all of you. Next week, again, we're going to be meeting here. Wonderful evening ahead with a great topic by Dr. Maluleka. So I really encourage you to all be here again, same time next week. Thank you so very much, Jenny. Amber, have a blessed evening forward. Have a good night.
Thank you so much, Burton, and thank you, everybody. Have a lovely evening.
Thank you so much. Good night.
Bye.